Stop talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. Hey, you want to talk? You want to run your mouth or whatever it is? Boosie said, "Set this off." Yeah, that part. Man, I don't know. This is what happens when you think you cool with somebody and then you need a favor and then yeah, that part. That part. But anywho's, if y'all have not heard the news, here's the news. Bootsy paid $600,000 for a presidential pardon that never showed up. And now the people he paid are trying to get his entire case thrown out before a single fact gets argued. We got to talk about this, y'all. I'm Cassandra, your favorite paralegal, and this is Legal Doc Talk. So, we're going to be covering the arbitration between rapper Boosie Badazz, his real name is Torrance Hatch, and the political operatives, and I'm doing quotations, Jacob Wall and Jack Berkman. Y'all, this is kind of wild. I was like, let me dig into this a little bit more and see what's going on. So, I'm gonna give y'all a quick background about Bootsy right quick, but I want y'all to understand that an arbitration is some places call it a mediation, places call it an arbitration. So arbitration, mediation, pretty much the same thing, but it can happen before you even file a lawsuit or during a lawsuit. Okay. And so right now that is what he's doing, like Boosie said. And this is not something that I don't think he just did this. And we'll get into that, but let's get into it. So, what I'm going to pull up on a screen, two documents we're going to look at. We're going to look at the retainer agreement that he supposedly signed, and we're going to look at what the attorneys actually filed the motion to dismiss. All right, but a little bit of background. So, Boosie was facing sentencing on a federal felon in possession charge, and according to public reporting, he hired Wallen Berkman's firm, J.M. Berkman and Associates, in the fall of 2025, and he paid $600,000 for help securing a presidential pardon. The pardon never came through, y'all, and now Boosie is seeking his his $300,000 refund, which he says is required under that contract, and we'll get to that section in just a minute. So he ended up filing a demand for arbitration with the American Arbitration Association to pursue his $300,000. Okay. Now, before we get into the filing itself, let me give y'all some context on who Bootsy tried to hired to get this pardon. Wall, Jacob Wall, and Jack Berkman pled guilty back in 2022 to running an illegal robocall scheme targeting black voters in Ohio, discouraging them from voting by mail. That resulted in felony convictions, a multi-million dollar fine from the FCC, and a settlement with the New York Attorney General. Now, according to investigative reporting from Notice, I actually signed up with them so I get newsletter. But according to their reporting, during their work on Boosie's pardon push, Wall and Berkman repeatedly told Boosie's attorneys that they had connections to a well-known Trump world political figure, and claimed several prominent political and media figures supported Boosie's pardon. But when Notice reached out to those particular individuals, multiple people denied that they ever advocated for Bootsy, and some even said they didn't even know who the world he was. I'm not laughing. I'm laughing, but I'm not laughing because it's just like you thought that they were your friends, my boy. But anywho's, a White House official also told Notice that the clemency team had never ever heard from Wall or Berkman at all. Not an email, not a call, not a visit in person. But none of that is part of the actual arbitration filing, but it is useful background information for why this dispute is getting so much attention beyond just the contractual fight. Like you literally hired two scammers. Let's walk through that. You hired scammers, okay? So on the screen, let me pull this up. We're gonna look at this. So this is what they filed. So this is called a verified motion to dismiss and protective answer. This is what the respondents, Wool and Berkman, filed. So we're going to break this down, what each part means, and what the arguments will raise. So this first part, the first paragraph, they were talking about service. And y'all have been with me long enough to know anytime you file a lawsuit, you have to serve the other party because they have to be notified about that they're being sued, for one, and two, you have to allow them to be served. Same thing with an arbitration. So their first argument was that the demand for arbitration was allegedly never formally served on the respondents, neither by Bootsie's side nor by the American Association of Arbitration or Arbitration. American Arbitration Association. I think I said that backwards itself. But in both litigation and arbitration, like I said, proper service is often a threshold jurisdictional requirement. It's not something that you can skip. If service didn't happen correctly, the argument is that the arbitration technically never got off the ground. Just like in a petition, if you file a petition and the other side doesn't respond, or no, if you file a petition and you can't serve them, it doesn't matter if it's process server, if you leave it on the door, well, that's a whole nother different thing. If you do citation by pub, whatever, there's multiple ways you can serve it. But for arbitration, if you never serve them, it's like it never happened. All right. The next paragraph says, secondly, the expired retainer agreement. And this is the agreement that they are talking about. Okay. Um, if you want me to send this to you guys, I'll definitely do it. But this is the agreement. And I'm just quiet because I'm scrolling in case y'all want to stop. So that agreement was dated September 25th, 2025. DocuSign signed by look like John. It says John Berkman. It don't look like Jack. But anywho's shows Jack signed 9/30/2025. And then Torrance signed, aka Boosie Badazz, signed on 9/30/2025. So keep that in mind. Keep that in mind, guys. So the retainer agreement I just showed y'all is one of a disputed fact. This is actually the centerpiece of the whole motion, and it is worth walking through carefully because it's generally contested. So the retainer refund clause is tied to a January 31st, 2025 date. I'm going to pull that up. Where is that? Right here. Paragraph 2. Okay. It reads that if a full presidential pardon for the matter is not secured by the client by close of business, 5 p.m. Eastern Standard Time on January 31st, 2025, consulted shall refund 300,000 United States dollars to the client. This refund is conditioned upon the following procedures. The client must submit a written request to the consultant for the refund. Consultant shall return the funds within 3 business days of receiving the client's request. The funds shall be transferred via bank wire transfer. Uh, via, what is this? Via bank wire to a bank account designated in writing by the client. All right, so everybody see that, right? All right, so the contract supposedly and reportedly was signed on, and we're gonna go down here, what we say, September 30th, 2025. Now it says months after that date. Respondents argue that under basic contract law, you cannot accept an offer after it has expired. And there's a doctrine called a lapse offer where once a deadline passed, there's nothing left to sign onto. But here's the important counterpiece, because I know everybody like, wait, it said January 31st, 2025, and then they both signed September 30th, 2025. That's months after, but hold on, that's the counterpart. So reporting from Notice again indicates that Boosie's legal team says both sides understood at the signing that 2025 was simply a typo for 2026. All right. So if that is accurate, then that wouldn't be a lapsed offer situation at all. It's just a simple clerical error, which courts and arbitrators can often correct without voiding out that contract. So this argument isn't a guaranteed winner for the respondents. It is a factual question about what the parties actually intended, and that's exactly the kind of dispute arbitrators resolve by looking at the evidence, like surrounding communications and conduct of the party. So if there's emails or something that say, okay, yeah, we see that the dates is incorrect, it's supposed to be 2006, but we put 2005, but we'll go ahead and just say everybody on the same page, it's 2026. Okay. Now, here's the part that's going to trip y'all out. So the second argument is the motion raises a question about who actually signed the retainer agreement, pointing to the metadata that allegedly identifies a different signer than Hatch himself. This goes to contract formation, because if the signature isn't authenticated as belonging to the party bound by it, that's a foundational problem for enforcing the whole agreement. Y'all watch this. So we have John Berkman, right? Y'all see how it says signature John Berkman. We go on Torrance, it says J. Cooper. So J. Cooper is the one who signed this, but he signed it as Torrance Hatch. So it's just like, okay, who actually signed this agreement? Mm-hmm. Yep. Y'all see that? Do y'all see that? So that's actually something that is questionable. But once again, that's the whole purpose of the arbitration. The next argument I believe that they made regards, let me see, expired. I'm trying to get down so y'all can, okay, offered lapse, next board, was it signed by the claimant? Okay, so now it talks about the number of arbitrators there. So I like to put it on the screen so you guys, if you want to read it, you can read it by yourself. Oh wait, hold up, liability. I skipped that part. Oh yes, that's what we need to talk about, because they are saying that, okay, yeah, next, they were never personally a party. Okay, I'm looking at my notes. So, individuals versus LLC liability. That's another argument. And this is a concept that comes up constantly in business litigation. So, Wohl and Berkman are arguing here that they were never personally parties to the contract, only their LLC was. And generally, individuals aren't bound to arbitrate personally unless they sign in their individual capacity or there's a legal basis to pierce the entity, like fraud or alter ego liability. So, this is the flip side of the corporate veil protection business owners rely on. Thus, the reason why they do an LLC. Okay. And then last but not least, I think this is where I was coming to the arbitrator part. Um, so the fourth thing, this is a smaller but a real procedural point. So the underlying agreement that you see here calls for either one or three arbitrators, and respondents argue that the demand never specified which. In arbitration, these procedural details actually matter to whether a demand is properly constituted. Child, ain't this crazy? Ain't this crazy? See? And it shows right here. Shall be solely and finally settled by a board of arbitrators consisting of either one arbitrator or three. So in his demand, he would have had to specify how many arbitrators he was wanting present during arbitration. Yeah. Now, here's a smart procedural move. Alongside the motion to dismiss, counsel also filed a protective answer. That means we don't think you have jurisdiction over us at all, but just in case you disagree, here is our general denial and 17 affirmative defenses. And let me pull that up. I hate when I click on that. So here's the general denial where they deny each and every allegation that is listed in the demand of arbitration. And here are the affirmative defenses. And I'm going to scroll. Yes, a lot. Oh, I'm going to just read it. Okay. They talk about failure to state a cause of action, failure to mitigate, damages claimant's faults, unclean hands, waiver, estoppel, and consent, avoidable consequences, damages are speculative, attorney fees, ratification, justification, um, I need to look that word up, but that word, proximate cause, good faith, failure to provide notice, lack of jurisdiction, and economic loss doctrine. So that's all. And so the and it's good that they did that because it preserves their portion of the merits without waiving the jurisdictional argument. Defenses raised include failure to state a claim, like I said. You saw the failure to mitigate damages, unclean hands, waiver, estopper, and so much more. All right, so they included those in their protective answer, which is smart. Now, why does it matter? Here's why this case is such a great teaching moment, guys. It shows how a jurisdictional challenge can be completely reshaped and how it can reshape a case before the substance is ever addressed. If the arbitrator agrees that the retainer agreement and its arbitration clause was void from the start, the entire dispute gets kicked out of arbitration and potentially have to be refiled somewhere else, like in court. So if the arbitration don't work, Boosie could actually file a lawsuit against them in court. And it's also worth zooming out for a second. This is reportedly the first known arbitration filed against a pardon lobbyist during this administration, and it's a window into what's being called a growing pardon economy, where people with real or claimed informal access to the White House are charging significant fees to advocate for clemency, with very little oversight over who's actually delivering results versus just who's collecting a check. Because, Boosie, you didn't do your research on these people? You didn't Google? I'm sure when you Googled them, something had to pop up in the news of what they did. But I guess you didn't care, huh? I wonder. But this is very much still unfolding. I'm going to keep you posted as it develops. If you have any questions, definitely drop in the comments because I do read everyone. I may like it. I may respond to sometimes, but not all because I get so many. But if you definitely learned something today, hit the like button, hit subscribe, and I'm gonna catch y'all on the flip side. Bye.